SJC-12914, Massachusetts Coalition for the Homeless v. City of Fall River.
Thank you. Ms. Borkman.
Thank you, Your Honor. May it please the court. The Massachusetts Coalition for the Homeless and two of its low-income members, who together have been charged by Fall River Police 43 times for asking for contributions from motorists, respectfully seek a declaration that the statute at issue in this case is facially unconstitutional because each of its only 3 sentences, individually and in combination, violates 4 bedrock free speech principles. First, asking for contributions for one's own support is constitutionally protected speech. Second, laws that differentiate on the basis of content cannot qualify as reasonable time, place, and manner restrictions, which is why Fall River's primary argument fails. Third, laws that give government the power to grant or withhold permission for free speech must contain clear standards to guide discretion, which the second and third sentences of this statute clearly lack. And finally, and precisely because the First Amendment and Article 16 are intended to protect speech that may be unpopular, a law that discriminates based on content or the identity of the speaker is subject to strict scrutiny, which the government cannot satisfy here because the law is both under and over-inclusive in relation to its stated purpose, which is traffic safety. It is perhaps not surprising that this statute, in all seriousness, is a law school exam-worthy example of how to violate almost every free speech principle in only 3 sentences.
Ms. Booker, can I ask you a question? I think the big issue that we'll get to in a moment is whether or not this can be saved, because given the complexion of the litigation, I think that's where it leads us. But before we get there,
Yes,
in order for it to be speech, there has to be a public forum. I get that, and this statute is so broad, it covers all highways and byways. And obviously, you know, the local Rotary in Dorchester, State Street, Day Boulevard, these are places where people, you know, hold signs and protest, and that's certainly a public forum, as we recognize in the benefit case. But what about in Bristol County, like, you know, a median strip on Route 495, if someone wants to protest out on the median strip with cars whizzing by at 90 miles an hour like they drive on that highway, is that a public forum?
certainly on this record, it is, Your Honor. I direct the court to the 10th Circuit recent decision in McCraw versus Oklahoma City. It's at 973 F 3rd 1057, talking about streets and medians being public forums, and that the burden is on the government to show that there are particular places where traffic safety may be an issue that would justify a law that's narrowly tailored to those particular places. But here, where the statute is, it's both under and over inclusive, I would point out that the traffic safety is not even an element of the crime here. So for instance, people merely standing by—
The statutory scheme is in traffic enforcement, right? It's within the traffic safety laws.
It's within that statute, Your Honor, but I'd like to point out this was enacted in 1930, and which was a decade before the First Amendment was even applied to the states, and a decade and a half before Article 16 was amended to protect free speech. And from its beginning, it combined both conduct and speech as interrelated elements of the crime. And this court has made clear in Commonwealth versus the Juvenile, and the Federal District Court in McLaughlin versus Lowell at page 193, relying on the Supreme Court's decision RAV, made clear that where both the contact and the speech are necessary elements of the crime, even if the conduct could be prosecuted, the speech cannot be.
So to answer my question, I guess what you're saying is because the statute is so broad as far as highways and byways, it would have to be incredibly narrow to exclude really dangerous.
Yes, Your Honor. It's just, the statute is very much overbroad because it
Okay,
doesn't
so we have protected speech, all right? And then, and there's no debate about that from either side. And we have a statute that picks winners and losers for speech. So that's bad. So we go to strict scrutiny.
Yes.
All right. If I take the judicial meat cleaver out to the statute, can it be saved?
With all due respect, Your Honor, we do not believe this statute can be saved, and that's for multiple reasons. First of all, if we understand the Commonwealth's position correctly, they are, at this court, suggesting that the remedy is merely to excise the word soliciting any alms, even though in the lower court, they admitted that at least the entire clause soliciting any alms, contribution, or subscription was unconstitutional. And even though plaintiffs here have never been charged with seeking alms, if you look at the records, the state police records, the other records in the record appendix, they're charged with soliciting monies, not either alms nor contributions. And this court in Benefit specifically described what our clients is doing is seeking contributions. So it's very clear that at least that part of the statute must go. But then even the remaining part of the statute, when you take into account the First Amendment overbreadth doctrine, remains unconstitutional in its entirety. It would, the bar on selling things by the side of the road, which is something low-income people often do to try to help themselves make ends meet, is still content-based, standardless, and not tied to traffic safety. Again, as discussed in our brief, in our reply brief, someone is charged merely for standing by the side of the road with a sign and not interrupting traffic whatsoever. So that part of the statute could be brought to, someone could pull over safely to some place and get out and hand somebody $1 for a rose. That doesn't interrupt traffic safety, yet that would be covered by this statute. And finally, even if the court took out the cleaver and engaged in the quintessential legislative work, in the words of the court in Ramirez, and took out the whole purpose of the law.
And I'll let you finish, but we have a statutory obligation to save. We have a common law and a statutory obligation to save statutes when possible. You know, we look at General Laws Chapter 4, Section 6. We have to sever, and you know, we have lots of cases. Justice Link wrote one recently that says that when possible, we have to avoid unconstitutionality, right? So we
do understand that, Your Honor, but we think it's not possible in this case, with all due respect. And that is because even without the for the purpose of clause, then the statute, which may be inconsistent with legislative intent, because this is never the way the legislature wrote it, but then it would say, whoever signals, causes the stopping of, or boldly confronts a car can be charged with a crime. And that would be wildly overbroad. Somebody could just be standing by the side of the road with a political sign. That would be subject to charge.
So it would criminalize anybody who essentially interferes with traffic for any reason whatsoever.
It doesn't, it's broader even than that.
If we did that.
Traffic interruption isn't even a requirement.
Ms. Borkin, just remind me, because we don't have a lot of briefing here. I mean, the AG sort of tries to save this in the last sentence of its brief. When we take out the meat cleaver in First Amendment cases, it's a different set of rules, right, than the severance doctrine outside of it. Can you remind me what those rules are?
Yes, Your Honor. Given the overbreadth doctrine in the free speech context, there is much greater obligation on the court to look at the statute as a whole and not uphold a statute that is overbroad. And for the reasons I just said, this statute is overbroad in every one of its elements. And this court recognized in Ramirez, which was a Second Amendment case, even there, that to try to excise and slice and dice the statute would go beyond the judicial function. And that wasn't even a case where this free speech overbreadth doctrine applied. But
So the break on this is when we get past legislative intent, correct? That's the breaking point on
Yes,
how.
Your Honor. And I would point out again that in 1930, this statute, the first sentence was enacted in 1930. The legislature always saw the two things conjoined: the purpose of your speech and the fact that you were signaling or causing to stop or accosting, which merely means boldly.
Well, in the legislative history, I don't know if it was addressed all that comprehensively, but it was to basically make sure people weren't cheated by people selling. They wanted to regulate those that could sell on the road and say, well, we're going to take care of our newspapers, but other than that, you have to register, correct?
Well, that seems to be the point, and that's why we're not really contesting that traffic safety can be considered as the underlying asserted purpose here. But the original enactment does give rise to a question of whether that was really the purpose, as opposed to prohibiting certain kinds of interactions with cars that people find annoying.
Yeah, protecting some merchants essentially.
Yeah. And it's, you know, it started out with the provision of that no one could signal, et cetera, a car. Then the legislature next year pretty quickly realized, oops, we better let newspapers sell. So they inserted a newspaper exception. Then in 1978, they decided, oops, we better let some other people other than newspapers sell, regardless of whether they're signaling and causing cars to stop. And then in 1990, they realized, oh, wait, we want nonprofits, but not individuals to be able to solicit charity, which this court recognized in Benefit as a viewpoint-based discrimination. I also want to point out that all of those, every piece of this statute was enacted prior to this court's decision in Benefit, prior to the United States Supreme Court's decision in Reed v. Gilbert, which made very clear the law around content neutrality and the need for it.
There's been a number of these challenges across the country, correct?
That's right, Your Honor. And some of them are collected in that decision from this year from the 10th Circuit that I cited, McCraw versus City of Oklahoma. And it's clear that in spite of apparent desire, because of the unpopularity of this kind of speech, efforts are continuing to try to restrict people's rights to seek donations. But time and again, the courts have struck them down. And one of the things we're concerned about here is that, notwithstanding that there have been 90 years worth of jurisprudence since this statute was first enacted, law enforcement keeps applying the statute, and localities keep enacting versions of it. In fact, if you check the City of Pittsfield's website right now, the City Council is considering enacting this statute as a local ordinance right now. And so one of the things that we would ask—
I take it by that answer that you don't, you're not appeased by the answer of the government that, well, we'll just enforce it properly.
Well, Your Honor, it's very clear. This court said in Bulldog Investors, quoting U.S. v. Stevens, that we don't, in deciding the facial constitutionality of the statute, we do not take comfort from individual governmental actors' suggestions that they will apply it responsibly. And in fact, what we need is, with all due respect, guidance from this court about when there are statutes like this that have been on the books for so long, and the law has evolved so far since they first were enacted, that law enforcement and other officials have an obligation to take into account that intervening law in making their enforcement decisions.
I'm sorry, I don't understand what you're saying, Mr. Booker. I don't understand what you're talking about. Just this statute, not any other statute, right?
No, yes, Your Honor, I'm talking just about this statute, and referring back to the fact that here the legislature perhaps could be forgiven, given that they enacted this so long ago and before recent precedent was on the books. But law enforcement, each day when they're deciding whether or not to apply this statute, should be taking into account the intervening law in making their enforcement decisions. They have the benefit of the benefit case, of the Reed versus Gilbert, and of the many other cases that have interpreted these laws to violate both the First Amendment and, in our case, Article 16 as well. So we would hope that the decision could give some guidance to local law enforcement about what to do in a situation like this, where there is an old statute that we submit is very clearly unconstitutional in its entirety, yet still on the books.
Let me ask you a question, if I might. I wanted to make sure I understood that you don't disagree that traffic safety could be a compelling government interest.
We are not contesting that, Your Honor. I will point out that the Supreme Court in Reed versus Gilbert cast doubt on that. They went out of their way to assume without deciding that traffic safety was a compelling enough interest to override free speech. But we're not contesting that here. We are taking the position that this statute merely is not tailored sufficiently to serve that interest because it allows so much traffic interruption and would impede things that are not traffic interruption.
Okay, thank you.
Anything further from Ms. Bork? All right, thank you, Counsel.
Thank you, Your Honor.
We'll hear from Mr. Casey.
Good morning, Your Honors, and may it please the court, Tim Casey, Assistant Attorney General for the Bristol County District Attorney Thomas Quinn. Let me begin, Your Honors, by apologizing. I'm not sure why I'm not visible, but
do you have a thing over your camera?
I don't think so. So I'm not sure what's wrong with my web camera, but I apologize. I hope you can hear me okay.
Yes.
We can.
Okay. Your Honors, the District Attorney acknowledges, as he has since the beginning of this litigation, that the portion of the statute at issue in this case is unconstitutional as a content-based restriction of speech, insofar as it imposes a fine on those who stop or signal a moving vehicle or accost the occupant of the stopped vehicle on a moving way, if that conduct is undertaken for the purpose of soliciting alms, so-called panhandling, while exempting the very same conduct if undertaken for other purposes, such as selling newspapers or seeking contributions for a nonprofit with a permit. Because the statute prescribes or permits the same conduct dependent upon the expressive purpose of that conduct, this portion of the statute is unconstitutional.
Just the alms portion?
Your Honor, yes. I think.
Right. So if we have someone in front of you being prosecuted for selling roses for $1 who's homeless, and that person would still be charged with a crime, correct?
Well, Your Honor, I think it would be a different constitutional question. I think the other portions of the statute are regulations of commercial speech that proposes commercial transactions.
Well, okay, let's get back to the charge you have in the Taunton District Court, right? They call you and they say, we got this guy who was caught selling roses for $1 and he doesn't have a permit, and you're allowed to sell the Taunton Gazette on the highway, but you're not allowed to sell roses for $1. Is that a problem?
Your Honor, I think that would be a different constitutional standard. I think it would be that would be a regulation of commercial speech. I can't speak to whether that on those facts a case would be prosecuted, but
no, that's the statute. You want us to take our judicial rapier, I guess, not a meat cleaver, and get rid of that one alms portion to save the statute. And I'm asking you about a content-based winners and losers scenario under the statute. So is that constitutional?
Your Honor, I think it would depend on whether it survives the standard applicable to commercial speech, which is typically considered a form of intermediate scrutiny. As you know, we assert that traffic safety is a compelling governmental interest. I don't think Reed casts any doubt on that. It simply assumed without deciding that that traffic safety is a compelling governmental interest, but that the regulation there was not narrowly tailored to further that.
If I drive by a rotary and there's a group with MAGA hats on that say beep if you love Trump, and then there's another group with Biden-Harris stickers saying beep if you love Biden-Harris, and then there's a Black Lives Matter protest down the road and they're asking me to stop and wave. Is that okay? Because we just got rid of the one thing involving alms.
Your Honor, I think that unless there's a solicitation of for a contribution or a selling merchandise, then I don't think that conduct is reached by the statute.
But they're asking people to stop, right, and wave.
Right, but it is not for the.
They're signaling motor vehicles in a public way, or they're causing them to stop.
But they are not doing so for the purpose of soliciting a contribution or subscription or selling any merchandise. So,
I have real, Justice Gossett, are you done? I don't mean to cut
Yes,
you
I am.
off. I don't.
I'm perplexed, but done.
Yeah, the AG is not giving us much guidance here. So Ms. Borkin's arguing that the statute's unconstitutional on its face. You're trying to save most of the statute, but I've got no legal analysis from you on how we do that. And the statute is clearly unconstitutional in certain respects. But so don't you have to provide us more here, or if we're going to try to save this? Because you're not giving us any legal analysis on this.
well, Your Honor, that's because, in part, many of these arguments were raised for the first time in the reply brief. We acknowledge that there was reference to a facial challenge to the statute, or the statute being challenged on its face prior to the reply brief. But there was no development of any argument prior to the reply brief about the overbreadth doctrine, about the commercial speech doctrine, about a reference in the reply brief to vagueness in the standards to be used for issuing permits. So
what do you want us to do? Declare this statute unconstitutional as applied, and not do anything else? I mean, that I can understand is sort of, you're giving us some analysis there, but I don't know how we save the statute without any legal analysis, unless we're going to do it by ourselves.
well, Your Honor, that is what we are asking the court to do, to consider this as an as-applied challenge, and to we acknowledge and concede that the statute as applied to the conduct of these plaintiffs is unconstitutional.
Is that how you understood their argument in the past? Is that how you understood their argument below, that there was as applied, as opposed to on?
No, Your Honor, but I understood it. We understood it to be a case where the only conduct the plaintiffs alleged to have engaged in was soliciting alms, raising money for themselves. And
Yes,
so we do not think this was.
I think they've been pretty clear that they think the entire statute is on its face invalid, right?
Well,
So I guess I'm
it is now.
Justice Kasker's question to you, which is, why didn't you address this before and help us if this is what you want?
Well, because our position is that it's enough to resolve the case to conclude that it is unconstitutional as it is applied,
and that's not what the question is it?
But don't, I mean, again, I'm relying on nothing from the briefs, but it's really difficult when you do this type of analysis in the First Amendment context. And I just don't remember the rules. I mean, I guess we can go back and have our law clerks do all the stuff we normally get in briefs, but it just seems difficult for us to, on this argument, do much here, because this is really complicated stuff when you try to save parts of a First Amendment statute on a First Amendment argument, isn't it?
It is, Your Honor, but those, I would assert are reasons to decide the case narrowly and on the basis of the conduct that the plaintiffs themselves are alleged to have engaged in. We acknowledge that the First Amendment is a unique context where there is an exception, a limited exception to the usual rules of standing and justiciability. But as the Supreme Court itself has acknowledged, overbreadth is strong medicine. It is to be employed as a last resort. And I would like to make a couple of points about overbreadth, even if the court reaches that issue that counsel against its application in this case. First, the Supreme Court has stated a preference for deciding cases on an as-applied basis, even in the First Amendment context, where it is not.
Even when the brief from your opponents is an on its face challenge, the U.S. Supreme Court says we should convert them to as-applied decisions. Again, you may be right. I just don't have any analysis on that, except for memory.
Your Honor, well, let me read from one Supreme Court decision, Board of Trustees of State University of New York against Fox, 490.
Mr. Casey, you're going to need to get closer to the microphone or your phone.
I'm sorry, Your Honors. This is Board of Trustees of the State University of New York against Fox, 492 U.S. at 469, 484, 485.
I'm sorry, could you do that again? Did you just cite this in the briefs?
It's not in the briefs, Your Honor.
192 U.S. what?
469 at pages 484 to 485.
What year is that, please?
1989. It is not the usual, this is from the Supreme Court, it is not the usual judicial practice, nor do we consider it generally desirable to proceed on an overbreadth issue unnecessarily. That is, before it is determined that the statute would be valid as applied. Such a course would convert use of the overbreadth doctrine from a necessary means of vindicating the plaintiff's own right not to be bound by a statute that is unconstitutional into a means of mounting gratuitous wholesale attacks upon state and federal laws. Thus, for reasons related both to the proper functioning of courts and to their efficiency, the lawfulness of the particular application of the law should ordinarily be decided first. And then I would like to refer to the court to one of its own decisions in Bulldog Investors, which says that the overbreadth doctrine is not applied in commercial speech cases because the concern that speech will be killed is much weaker in the case of a commercial speaker. That's 460 Mass 647 at page 677. Here, the other statute, the other conduct, or rather the other purposes of the conduct that is regulated by the statute are for the purpose of engaging in commercial transactions. So they would be subject to the commercial speech doctrine. And under this court's decision in Bulldog Investors, which cites a number of US Supreme Court cases, the overbreadth doctrine does not apply to commercial speech restrictions. So,
Does that include nonprofit organizations?
well, if it is speech for the purpose of engaging in a commercial transaction, then I think it would be arguably a commercial speech regulation.
Can I point out a question? I have a question that's a slightly different question, which is in footnote 1 of your brief, you point out the ambiguity over whether the statute exempts the selling of, quote, tickets of admission to any game show or exhibition, unquote, and state that it's immaterial to the results here. Is there a scenario in which it might be material to whether the statute is narrowly tailored, or is it only immaterial because there are other exemptions at play here?
Well, we asserted that it was immaterial because the plaintiffs did not allege that they engaged in that kind of conduct, and so they were not subject to that portion of the statute, which is part and parcel of our argument that the court should confine its decision. We are emphatically not asking the court to rewrite the statute in any respect. We are simply asking the court to confine its decision to only that conduct that the plaintiffs are alleged to have engaged in that brings them within the scope of the statute, specifically soliciting alms or, if you like, contributions for themselves.
Can I ask? I don't understand how the So if this is a public safety statute, and I don't understand why selling roses is less dangerous than asking for money. You're doing both in the street. Why would, don't we have to, all the content-based aspects of this have to be declared unconstitutional, don't they? Not just the soliciting for yourself stuff, because everything, it just shows a complete inconsistency about whether there's a public safety rationale here.
On mute.
Yeah, Your Honor, I don't think that's quite right. I don't think that Reed, for example, displaces or overrules the Supreme Court's commercial speech case. So I don't think in the commercial speech context, the fact that a law may treat different or similar types of activity differently changes the commercial speech analysis. I think it is still a question of whether there's an important governmental interest involved here. There's clearly an important governmental interest, arguably a compelling governmental interest in traffic safety, and whether that regulation is reasonably related to further that interest.
You think it is? You think it is?
Well, I think it would be far preferable to develop those arguments through plaintiffs withstanding to raise those claims and with evidence and with full briefing and argument. To go back to a discussion that we were having earlier, I think the fact that these arguments and these points aren't developed in the case is a reason not to reach these issues.
Well, I want to know when it was that you raised your position about it being as applied case as opposed to on its face case. When did you first assert that?
We asserted it when we first stipulated to and requested that the Superior Court enter judgment declaring that the statute is unconstitutional. Now, Ms. Borkman identifies a slight distinction in the portions of the statute that we identified as unconstitutional. I believe that before the Superior Court, we referred to soliciting any alms or contribution, whereas in our brief to this court, we focused on soliciting any alms. But our acknowledgement and request for a declaration that the statute is unconstitutional was focused on the portion that is applicable to these plaintiffs.
So you would have us excise that from the statute, in other words.
Yes.
So be on its face, not just as applied to these plaintiffs.
Your Honor, we would ask that the portions of the statute that prescribe soliciting alms or arguably contribution insofar as their contributions for oneself are unconstitutional.
Okay.
Any further questions from Mr. Casey? Thank you, Mr. Casey. Thank you, counsel.
Thank you.